All right, welcome back for our final session talking about the remote workforce. I'm pleased to introduce Jillian Kornblatt, Rebecca Bernhard, Tim Goodman, making a second appearance today, and Melinda Maher to talk about some challenges that are really front and center right now for employers dealing with the new world in which people are working. I'm glad to see so many of you have stuck with us. This one's going to be a little bit more fun. It's certainly very timely. And with that, I will turn it over to Jillian.
Thank you, Ryan. And, maybe it's just some lawyer's idea of fun, but we hope it'll be entertaining for you. So we have Tim Goodman and Melinda Maher, who are both partners in Dorsey's benefit compensation group, and Rebecca Bernhard and I, who are both partners in our labor and employment group. And we can start with the next slide, and we're going to try to give you some thoughts on working from home. So as we heard in our prior panels, remote work isn't going away. Work from home isn't going away. It's really down to a matter of, how is that going to happen? How much will be allowed? How much will different workplaces allow? And when you think about it, though, it's really not just work from home. It's work from my cabin or work from an Airbnb. Even you may have had or certainly have read about people moving to different states because they now have the opportunity to live in their dream location without being tied to the office. So really, it's a work from anywhere question that we're looking at. And from what I'm hearing from clients and kind of generally seeing around, I think this is going to be one of the big issues in employee retention and talent acquisition over the next few years. So this presentation is designed to help you manage that. So with that, I will turn it over to Tim Goodman, who's going to start with the next slide with some payroll issues and taxes, right? Because those never go away. So thanks, Tim.
Thank you so much, Jillian. And I'll have to warn everybody, I don't think this was the part that Ryan was describing as the fun part of the presentation. That will come later with labor and employment law colleagues join us again. But payroll and taxes, payroll is really the unsung area of HR, but as everyone knows, when payroll isn't right, everything goes wrong very quickly. And so we're going to spend a little bit of time here at the start talking about payroll and taxes. And the first thing to think through really is about where taxes come from. And basically, states can tax an individual on two bases. One is, are they a resident? And number two is, did they perform services in the state? Or are they located in an office out of the state where that's where they primarily perform their services, right? So there has to usually be some nexus. A state isn't going to be able to tax an individual if that individual isn't at all connected to the state. Why this matters to employers, of course, is that employers are tasked with withholding those taxes. And I should note, when I say states, I should also note that it can include counties or cities. There are a number of jurisdictions where counties and cities also have taxes, for instance, New York or Ohio or other states. And so it may, when you hear states, think not just states, but also localities here, just to complicate things even a little bit more. As the second bullet here really indicates, the second big bullet, states have a variety of rules. Sometimes states have exclusions, which will allow you to work in another state and not be taxed. Sometimes as soon as you set foot in that state, you're taxed. And sometimes it varies depending on what your profession is and what you're doing. And of course, some states have no income tax at all. So there's this whole wide range that employers who have people who are working from different jurisdictions have always had to comply with. But now with the pandemic and more people working remotely, this issue has blossomed, I guess you could say, and employers need to be much more on top of this. And so what are the employer concerns really? Well, in particular, the employer needs to be thinking about, does the employer need to be withholding or reporting income tax somewhere? And if it fails to do so, then it needs to maybe pay some penalties, or it might be in trouble in terms of that jurisdiction. So those are the things we're going to cover here in like the first 5 or 6 slides. I'm going to go through a series of different states just by way of example. To just do a presentation on this would take hours probably to itself. And if we had 3 people holding out there, they'd get awards. But at least let's cover this as a basis and go from there. Could we go to the next slide, please? So here's some examples. And we're going to start here in the middle of the country a little bit with examples of people who are working remotely. They're doing remote work from a state other than their normal work location. So, for example, here, you could suppose the person was normally working in Minnesota and they'd gone to Iowa, North Dakota, or Wisconsin, by way of example, or they're from Michigan, they've gone to Iowa, North Dakota, or Wisconsin. What does that kind of mean? And to just go through these, and then I've got a few sites to resources here. Normally, if a person is working remotely from Iowa, that employee is going to be subject to income tax for the state of Iowa, okay? However, the employer is not considered to have a business nexus. It would not necessarily be required to withhold and report during the COVID pandemic. That's some guidance that has come from the Iowa Taxing Authority, okay? There's very similar guidance from the state of North Dakota. If an employee is working remotely from North Dakota, the employer doesn't normally have a business nexus, so the work is occurring due to COVID again, then the employer is not required to report and withhold, although the employee, again, would owe income tax to North Dakota, okay? State of Wisconsin, very much a similar thing. You would have the individual having an income tax obligation. And again, the employer doesn't necessarily have to report and withhold the amounts, right? You don't see South Dakota on here because South Dakota doesn't have an income tax, and so that just shows you some of the variety here. But one of the things that I don't know that employees who are working remotely have thought about is the fact that they may end up owing taxes in multiple jurisdictions if they've been working remotely for some period of time from a state. And this gives you some example of how some states are handling this, and in at least the first two instances, this guidance is they're making an exception on how things work due to the COVID pandemic. In other words, they're providing some relief. Could we have the next slide, please? Okay, so let's now go to one of our coasts here, as we just got back from the prior presentation on coast to coast. And we'll do Massachusetts and New Jersey. Here again, we have the employee subject to income taxes, New Jersey as well. And again, there's not a necessity to withhold during the pandemic. And could we go to the next slide, please? But now let's go to the fine state of New York. And so here we have a situation, at least in where I've been discussing things, where the employee, again, is working remotely in New York. Normally there's no business connection. The employer would not be required to withhold. But let's give you a different scenario. Let's say that an employee normally works out of a New York office and has been telecommuting from outside of New York. And so I want to read this, actually it's on the slide here, but just to be clear on it, if you are a non-resident whose primary office is in New York, your days telecommuting during a pandemic are considered days worked in the state of New York, in essence, unless your employer has established a bona fide employer office at your telecommuting location. So to put that into perspective, let's say you live in New Jersey, you commute into New York. Normally you're paying taxes in both New York and New Jersey due to the pandemic. You've actually gone to North Carolina or something, and you've been working on North Carolina. New York is saying, well, that's very nice, person, but we still are going to tax you on those telecommuting days. And that's the guidance then from the state of New York. New York is not alone in having this rule, and I've listed some other states here. This just illustrates that these tax rules can get very complex. Could we go to the next slide, please? And what would life be without California? And so remote work from California, again, the employee is subject to an income tax. However, the employer is not required to withhold again if the telecommuting is due to and during the COVID pandemic. And again, here's some of the guidance. I won't read through that, but I give you some links here. The bottom line, basically the HR area should really be checking and working with their tax department, with tax counsel, with payroll providers to make sure they're getting this right. It would not surprise me at all that states are going to need additional dollars to deal with the pandemic. States have been incurring a lot of additional costs. It's true that the federal government has provided states some aid, but I think states are really going to be looking at employers and checking on their payroll withholdings and reportings. And if a state has failed to follow and do the right things, I think those employers could find themselves with some penalties. And of course, just being audited in the first place, it consumes a great deal of time. So this is a very complicated area. And it's something where if you haven't been tracking it, it's very important, I think, to try and get on top of it as soon as possible to track it and be ready. Again, this was something that was happening even a little before the pandemic. It just has blossomed during the pandemic. Could we go to the next slide, please? So Employer reporting of health coverage. This is yet another reason to make sure you're tracking where people are working from in this remote environment. You know, the federal government already requires, of course, employers to file Form 1095-C with the federal government. Over the course of the last few years, a number of states in the District of Columbia have also adopted requirements. And so you see here on the slide, these other states that now have this requirement: California, Massachusetts, New Jersey, Rhode Island, all have filing requirements in addition to DC. Massachusetts has had it for quite a while. That's why the form number is slightly different. But basically, if you've got an employee who's a resident of the state, and if you work remotely long enough in a state, you might become a resident of that state, then in that case, you have a reporting obligation with respect to the health coverage provided to the employees who are there. And so yet again, this is another reason to make sure you're checking with your workforce and making sure you know where they're working and that you're properly getting that down so that you can fulfill these reporting obligations. Could we have the next slide, please? All right, another reason to know where your employees are and where they're working from. Employees who telecommute likely need equipment to do their job on a telecommuting basis. And so a number of states in DC require that employers reimburse employees. This list here lists off the number of the states that have that requirement, and there's a couple of examples here. For instance, California law provides that an employer shall indemnify his or her employee for all necessary expenditures or losses incurred by the employee in direct consequence of the discharge of his or her duties, right? So what does that mean? I've got an example from Illinois law here too, but what does that mean? Well, this is when you have to basically get into and see what guidance there is on the specifics. Does that mean that if you have a person who's working remotely from California or Illinois, or one of these other states, do you need to maybe provide them with some office equipment or reimburse them if they buy some, or help them with their internet connection or other things? These are things where the employees would have an ability to go back to the employer and say, you should pay me for these so that I can operate and perform services for you. So those are some of the payroll issues that come up and why you need to know where your employees are and what the rules are with respect to the state. Could we go on to the next slide, please? With that, I'm going to turn over to Rebecca to talk about some of the employment law issues with respect to remote work. Rebecca?
Thanks, Tim. So the tax man is certainly the biggest regulator that can come knock at your door, but there are other ones. And I know that some of the other panels talked a little bit about some of the wage and hour issues, like, for example, which states follow federal FLSA exempt and non-exempt tests. And you need to be careful about that because you could inadvertently have somebody who's moved to a state that doesn't follow the same exempt, non-exempt tests. And suddenly you might have thought they were properly classified as exempt and they may not be. Colorado would be a good example of that with some of the recent legislation. But there's also different minimum wages. At least 29 states have minimum wages that are higher than the federal wage. And there are a lot of localities that have living wage ordinances or minimum wage ordinances that are higher. Right here in Minnesota, in St. Paul, there's a minimum wage of $11.50 an hour, and it's going to go up this summer. So suddenly you might have had an employee who was properly paid when they were working for you in Minneapolis, and now they need to get a raise if they've working from their home in St. Paul. There's also prevailing wage laws that exist under the federal Department of Labor scheme. Most people think about the Davis-Bacon Act, which applies to construction. And so it's hard to imagine that that's going to change because the construction site is usually not at your home. But there is another comparable statute, which because I do a lot of work in the federal contracting and affirmative action world, many of my clients forget that they might be covered by the Service Contract Act, which basically covers non-construction. It covers service and supply federal contractors. So if you're providing services to the federal government, if you're providing supplies to the federal government, your employees might be covered by the Service Contract Act. And if they've suddenly moved to a location that has a higher prevailing wage determination than what you had them doing when they were physically at your location, you might need to adjust their wage rate for that. And those would, of course, apply to non-exempt employees. There's also a prevailing wage component to immigration matters. In particular, any employee that you have who's working on an H-1B is required to be paid the prevailing wage. And for those of you who have folks on H-1B visas, you know that if you've worked with us at Dorsey, we've had you help us fill out what's called a labor certification application, LCA, in order to have the Department of Labor certify that this is the correct prevailing wage for this job in this location. So, and it is a geographic, it's usually a metropolitan area. Obviously, in some of the more rural areas, the scope of that geography is broad. So if you're working in Minneapolis and your folks are now going to be working from home in the suburbs, chances are this doesn't affect you. But if you are in a more rural area, or if somebody has moved like Tim was describing, you may now need a new LCA determination that you're continuing to pay the correct prevailing wage, and you would have to file an amendment with the USCIS in order to make sure that the changing working conditions, i.e. they're no longer at your physical location and they're now working remotely, is considered a material change that might require an amendment to that issue. I guess that's probably ready for the next slide.
And now we get to the fun. Not that the tax issues and prevailing wage statutes weren't fun. Those were awesome. So go ahead and answer the first poll, please, audience, and we'll share the results with you. People must be considering carefully their choice. All right, here's our answer. So a lot of people unsure. That's very interesting and stands out. And you can see where the rest break down, but it looks like September 1 was the second most popular answer after unsure. Great. We have another poll lined up. We'll go to that one. Will you require your employees to get COVID testing before being allowed to return to work on site? Okay, and we'll see. Yes, so no testing. That makes sense, given the fact that the testing is not a permanent result. It obviously indicates status that day. But some people still considering it, some employers. Great, thank you, Sean, for queuing those up. And now we'll go back to Rebecca, who's gonna let us know. So when employees are off working in their warm weather for the winter, which saw a lot of with envy here in Minnesota this winter, what employment laws should employers be looking at?
Rebecca,
Yes, sir,
Rebecca,
Tim.
before you start, I was just going to let you know, we've got a question in here real quickly. Maybe we can cover it. What if an employee relocates without telling you, or even tries to hide the fact from you that they're working at a different location? What obligation does an employer have to verify an employee's remote work location? I welcome your thoughts. My quick take on that is, obviously, one approach is to ask employees periodically to complete or remind them to complete W-4s or W-4s for the particular state they're located in, to make sure the withholding is done correctly. And if they lie or mislead you on that, I don't think the employer then has a failure to try and collect the taxes. But I don't know if you have some additional comments on that.
I think the tax withholding implication is probably the biggest threat to employers if they let that be unknown. It looks like somebody else is asking a question about another country, and that brings up a whole another host of issues. Most of the employers I know have some language in their HR policies or employee handbook or similar that says you have an obligation, employee, to keep us updated on your personal information. And so I would use that as a means to basically require people to tell you if they're working somewhere or if they're changing their locations. Somebody earlier, either in your earlier in the tax conversation, talked about sort of what does it mean to sort of be relocated somewhere else and working permanently. And as you noted, every state is different. Is it 10 days? Is it, earning $2,000? Is it, and so that's why it gets really complicated. But as we saw, at least 30% of people aren't going back in the near future. So I think I would recommend that employers do keep in contact with their employees and ask them to report. We do have some slides later that talk about privacy issues and all of that. And again, as you can imagine, our friends in the East Coast, West Coast squeeze are going to have different rules about how invasive you can get with tracking your employees. But the short answer for what law applies is that generally, where the employee is performing the services is the protective employee statutes that would apply. But of course, many of those state statutes have a minimum number of employees in that state before they would apply. But let's take Minnesota, for example. The Minnesota Department of Human Rights, the Minnesota Human Rights Act, which is a little bit broader than the federal Title VII Act, applies as long as you have one employee. So if you are a North Dakota employer and one of your employees has decided to come back to Minnesota, you're now covered by the Minnesota the Minnesota Human Rights Act for that employee, because that employee is now in Minnesota. And the tension between federal and state laws for employees usually defaults to the one that's more protective of the employee. So you can't contract out of those kinds of protective remedial statutes. We heard a lot of that with regard to non-competes from both Aaron and Gabrielle and Siobhan, but it applies to things like minimum wage or discrimination concerns. Our colleagues talked a lot about the pay history inquiries. Now suddenly you thought you didn't have to worry about those laws, and you listen to Ryan and Molly tell you that they might come to Minnesota, but right now they're not here. But lo and behold, you got somebody who moved to Colorado because they missed the mountains. Now suddenly, if you're going to start recruiting that way, you're going to be covered that way too. Workers' compensation and unemployment are also schemes that are managed by states. And so if you've got people who are working in other states, you now need to be mindful of the unemployment contributions that you might have to make, even if you don't have the income tax withholding obligations. Most states believe that you should be contributing to their unemployment scheme if you've got an employee working in that state. And workers' comp is also going to be implicated depending on where and how folks are working. And that brings up a whole host of issues with regard to, is their work environment a safe environment? Do they have a good setup? And are they in states that have more restrictive laws about ergonomics? Are you helping make sure their home office is set up properly?
Yeah,
So,
many aspects here.
Yeah. I'm happy to go to the next slide.
So Tim, many of us have been already enjoying the web of state and local laws on paid leave, and now we have another layer. So what's been going on with COVID benefits in that respect?
Yeah, and our colleagues earlier talked about all sorts of developments with respect to paid leave laws in different locations. And here, there's a couple that we just wanted to point out in particular that are state and local COVID paid leave laws specific to COVID and the pandemic or applying to a public health emergency. And so we wanted to call out two states in particular. I won't spend a ton of time on these in part because Gabriella addressed them a little bit already, but California has its supplemental paid sick leave rules, which are giving employees, in essence, a guarantee of a certain number of hours of paid sick leave. And I say for the FFCRA reasons, every state says this is a little different, but it's basically if it's related to COVID or you're being tested for COVID or you're quarantining because of COVID or you're caring for a family member or a child can't go to school. I shorthanded it there, but that's the general concept. And so the core thing is that employers need to communicate to their employees these protections and also to post notice about these. And there's requirements on doing that electronically, given that a portion of the workforce, of course, is working remotely. In addition to the two states, there's also a number of localities that have adopted similar COVID paid leave requirements. And these are usually in addition to and on top of regular paid leave requirements that are being adopted by the states that our colleagues kindly covered earlier in other presentations. I've seen a few more questions come in. I think we have a moment to take at least one or two of them and not fall too far behind, although now they're coming in even quicker, but we can start with one or two here. Maybe we just try the following question or two. when a state law says it applies to an employer with X number of employees in the state, and how is that calculated, or an employer with X number of employees? So let's say it says if you're an employer and you have 25 or more employees, this law applies. How is that calculated? Just the employees in the state, or the employees the employer has nationally? Jillian and Rebecca, I turn this over to you too, but I'd say I think that just depends on how the law is written. But I'd worry usually it's probably on a national basis instead of just
Yeah. And I did, yep. Oops, sorry, Tim. I did actually respond to that one directly. And you're absolutely correct. It does depend on the state and how they actually define it. And some do actually say if you have any employees in that state, then, for example, your supervisors, no matter where they're located, are covered. A good example of that would be the California Sexual Harassment Training Law. But others would say number of employees in that state. And so you do have to actually check the actual statute definition and threshold language.
All right, so there's a patchwork of which patchwork applies.
Yes, there is a patchwork of which patchwork applies. This is called the full, so COVID-19 is the Full Employment for Employment Lawyers Act.
Yes.
Well, we have one more question, then we can go on to the next slide after this. But the question, it says, are the California and Colorado COVID paid sick leave rules in addition to the FFCRA, or if we offer FFCRA, are we covered? And I guess, I would have to double check, but I think that they're both in addition to and supplemental to. Now, could the FFCRA, the FFCRA, just to be clear, is currently not active. It's a voluntary program, is how I would phrase it, under the ARPA, where you can voluntarily go ahead and provide paid sick leave and then be reimbursed through payroll taxes and so forth. These are separate laws that don't involve payroll tax reimbursement. If you're in California or Colorado and you're trying to comply with these laws, they're complicated laws, and you could see if maybe then you would adopt those, the ARPA's voluntary approach. But of course, then keep in mind, as our colleagues talked earlier, I think it was Drew, you'd have to adopt it for the whole 2 weeks in terms of getting back that. And here, the amount of that you have to pay the person, I believe Colorado or California, would follow the sort of FFCRA rules, but that's another thing you'd have to go through and confirm. So there is an interaction there, but I think you need to drill down more than we can do right now to do that. You want to take us to the next slide? Or, I'm sorry.
Do you mind if I jump in, Rebecca? There's one more question that you haven't addressed, and I think it's a fundamental one as our audience listens to all of these patchworks and dynamics and uncertainties. Can an employer just say, no, you can't go work in some other states. You got to be here, wherever here happens to be?
So I think the answer is, like all good lawyers, maybe. So it depends on what you've already set forth on your remote working policies. You certainly can't prohibit people from living where they live, but if you're moving people to come back to work, and if there is not some sort of ADA reasonable request to be working remotely, then I think you are pretty free to say, we need you to be within X minutes of commuting to the office for coming into work when you need to. If you are actually implementing a pretty generous, broad-based, everybody can work from home and we're totally fine with that, I think it's going to be hard for you to outright prohibit somebody from moving, but I don't think it's impossible. And the devil's in the details there on what your own policy says, what you're mandating, what type of work you're doing, and what your return to work policies are.
And I think a concern in that is you have to be really careful to track what you're saying and if you're enforcing it with everybody, because as we all know, when the superstar employee wants to move across state lines, is your management team really going to support terminating that person if they go through with the move? So I think it's a complex question. And then I think a lot of it also will depend on what peer organizations are doing, not from a legal point of view, of course, but for what do employers want to do to be competitive for employees in the next year or two. I was in HR before I went to law school, so I'm enjoying putting on my HR hat a little bit today. So we'll move on. Melinda, if you can tell us, oh, I'm sorry, I jumped the poll. So poll 3, will you allow employees who've been working at home to continue to do so? All right, what did people answer? hybrid model, wow, blows it away to the other two. I think that is, in anecdotes I've heard as well, that matches up, and it seems like there's a lot of pluses for everybody in that approach. Okay, now Melinda, can you please tell us what all this does to employees' health insurance?
Yes, thank you, Jillian. Actually, putting on my HR hat, the first issue we wanted to raise is really more of a practical one rather than totally legal, but it's really about looking at your health plan and worrying a little bit about your network. So in my experience, particularly our self-funded plan sponsors are pretty careful to make sure that their network is designed to cover where all of their employees live. However, now we're in a situation where we thought they lived isn't necessarily where they live. So that's going to have significant ramifications for these employees potentially, and unsuspecting. I mean, typically what I find or run into is the employees don't anticipate, that they're now out of network potentially, which depending on your plan design can mean a significant cost share on the employee. So that's something to think about, I think, and worry about. The one kind of countervailing point to that is the telehealth has just exploded since the COVID pandemic. We got a lot of regulatory relaxation on that, which resulted in many, many more opportunities for telehealth. I find that the coverage has expanded quite a bit in plans for telehealth. So that's one thing that may help with that problem. The other issue to keep in mind with your health plan, if you're insured, and if you are an insurer, is now potentially you may be insuring people in states that you did not think you were insuring people in. And so from a carrier's perspective, that's concerning because it affects their licensure. So you may have contracted, you may have bought a policy from an insurer who is licensed in particular states. Let's take Minnesota. If you're a Minnesota-based employer, you might have a carrier that's licensed in Minnesota, maybe in some of the surrounding states. However, now they may be insuring some of your employees in states that are far-flung, unanticipated, has regulatory implications in particular for the carrier. And finally, you might be triggering these health plan reporting obligations that Tim touched on earlier. So those are kind of some of the issues we've identified right now with respect to health plans. We can move to the next slide. We've also given a little thought to the dependent care flexible spending accounts because we feel that there's kind of some hidden issues here. Particularly, don't forget that in order to get a dependent care flexible spending reimbursement, the dependent care has to be in order for you to work, basically enable the employee to work or be looking for work. So what we're particularly concerned about is this idea that you're working remotely and you're working flexible hours. So let's say you're actually working at night as opposed to during the day, but you're going to submit a claim for dependent care reimbursement. We anticipate that the regulators are going to start looking perhaps a little more closely at this, particularly the IRS. And don't forget, if you have a non-working spouse at home, then that is not, and that would probably not be a legitimate dependent care flexible spending account reimbursement claim. Tim, I see you nodding. I don't know if you feel like you have anything to add. Okay. So that's it, I think, on those aspects. I think, Rebecca, I'm turning it over to you.
Oh, gosh, I hope it's Jillian because I don't remember the code.
Oh, okay.
I have the all-powerful code. And before I give it, though, I'm going to share a quick question. And it says that employer has been receiving a significant increase in applicants from other states who do not choose to relocate. So they're flagging that on their application. So I think that's really interesting. The question is, can you choose not to consider applicants of another state? I think, Rebecca, your thoughts on that. My thought is all the same things we talked about for current employees would apply to that decision, but curious what your thoughts are.
I think that's right. I can't remember which one of our prior panelists said, many of the laws haven't really changed, even though our world has changed. And so, especially if you were planning to return to work, if you're in the 70% that's going to hybrid or the other the lowest percentage we had on that poll was no, right? So unless you clearly are completely remote environment, then it would be hard for you to have a legitimate non-discriminatory reason not to consider people from one state instead of another state. But you might, I mean, as long as you're still abiding by those kinds of legitimate rules, you don't have to employ people remotely. You don't have to employ people remotely, right? I mean, you might, under the ADA, you might have to do some of those other things, but from a regular business operations, I think you just need to have a plan, and you need to have a sort of legitimate rule that can be applied, and then you can make sure you're applying it.
Very helpful. Thank you.
Somebody, I think Eric just said, is being from California a protected class? No, being from California is not a protected class, at least not that I'm aware of. Gabrielle can chime in. Yeah.
And with that, back to Rebecca. Talk about some compliance issues that come up with remote employees.
Yeah. So remember when we had water coolers and kitchens that people hung out in, and over on one side of those walls was this massive set of posters that probably nobody looks at. Those are required by the Department of Labor, and many states have comparable postings. So how do you post when nobody is actually in those water cooler kitchens anymore? So interestingly enough, the Department of, I'm going to talk about the federal posting, but many states have offered comparable relief in this remote world. Usually posters are supposed to be displayed in conspicuous places. I have the quotes there. It's so that it's easily visible to employees and actually applicants too, in some instances. But thankfully, took them till December 23rd, but thankfully the Department of Labor revised their field assistance bulletin. So this wasn't a regulation. This was just guidance to the field folks who would go in and go to your water cooler and see if you had those posters. They've decided that you may use an electronic posting. So for example, your intranet can be a sufficient substitute, but there are 3 conditions. All employees are working exclusively from home. All employees are customarily receiving information from the employer electronically, and all employees have readily available access to the electronic posting at all times. So for those of you that have a skeleton crew in the office, don't take down those water cooler posters, but go ahead and add them to your intranet. And I think that would be how you would meet that need. Next slide. Okay, so someone actually mentioned this in the chat, and I know that our East Coast, West Coast friends talked about this, and I actually think the other panel talked about this a little too. There are privacy tracking and software tracking things that people do, but many states have more comprehensive privacy laws than perhaps the state that you're currently operating in when you are operating in person. And so you need to be mindful that if someone's performing services in that more protective state, then that state applies. Before I went to law school and had my labor relations hat on, I worked in telemarketing industry. And so we had this whole 50-state survey of what we call 2-party or 1-party states for recording, right? And so the idea was, which states did you need both parties to consent to the recording of the telephone call, and which states could you just tell the employee we're recording it? And so there's similar kind of structures with regard to, for example, state versions of wiretap statutes, or state versions of the privacy in the workplace, which has to do with monitoring the email and all of that. And so you're going to want to make sure that you know which state your employees are in and whether that kind of tracking software is lawful. Some challenges. Oh, yeah, please.
Oh, I was just going to pop in, Rebecca, and say, you know, for those of you who work in organizations with compliance professionals, I am aware that these are very hot issues for them as well. So a good opportunity to partner on these issues.
That's right. That's exactly right. I wanted to just do a plug to some of our colleagues who had a presentation on March 31st of this year, but also with all of our HR hats on. A lot of folks have talked about sort of how do we do performance monitoring? How do we keep the mentorship? We think about that a lot here at Dorsey, right? There was a lot of mentoring between more senior and more junior lawyers just from the walking around and thinking out loud that happens in the hallways. And so I know a lot of folks in that 70% are probably trying to think about how do we keep that kind of collaboration and supportive performance management going on in a remote environment. And those really aren't legal. Those are really HR and talent management. But you always have to remember that the basic structure of the employment laws still applies even in the remote environment.
Thanks, Rebecca. And now we'll go back to some polls. So here's what I think the big one. Will you require employees to be vaccinated before being allowed to return to work? And let's see what people are saying. No. Wow, only 4% saying yes. I think that makes a lot of sense based on what we're hearing and what's actually possible at this point as well. And of course, Jack made some really good comments on whether you should do it, even if you could do it. I presented at a compliance training a few months ago, and when I said that employers could do the vaccination, could require it, the questions in the chat kind of blew up, and I think that a lot of other employees would have the same feeling. So, and one more quick question here. Will you offer an incentive to your employees to get vaccinated? Let's see, and people attending today, their organizations are doing. Sean, I think it's good to see the results. No, okay. So the majority are either don't know or definitely not doing it. Okay.
That actually surprises me. I was not surprised that most employers aren't, or that are attending, aren't mandating it, but a lot of folks are thinking about incentives. And of course, that makes me want to talk with Melinda and Tim if they are.
Yeah, it's a good topic. And I think like everything else right now, it could change as vaccine becomes more readily available too.
One thing I'll just tag on here, Jillian and
Sure,
Rebecca. So if an employer is thinking of offering an incentive, I guess I would say they should talk to somebody just real briefly about issues like, is that compensation? Is it being taxed? There's some ERISA and privacy issues there. So that's the quick plug on that. And then I'll let us get back to our slides because I know we're running a little short on time.
Well, that's okay, Tim, because you're up next. You can use your time how you want.
There we go. Okay, well, our next slide here is about corporate taxes, and that's something, fortunately, I hope nobody, not too many people, at least on the call today, have to worry about, but this is something we wanted to highlight for you to share, especially when you're thinking about this, because in essence, employers may need to consider if you're allowing employees to perform remote work, whether or not that might trigger additional corporate taxes on the company by allowing people to work from those remote locations. I am not the attorney who's the expert on this. We have fine people in our tax department and tax practice group here at Dorsey. But this is a consideration I think that should be looked into before, again, and somebody asked, do we have to allow people to work remotely? Again, there's a whole host of considerations there, but if you are allowing people to work remotely and as part of those considerations, you want to think, well, would this trigger then that we have to file corporate taxes in Montana or corporate taxes in Colorado or corporate taxes elsewhere? So that's a consideration. We just wanted to highlight that for you. We're not the right people, but we can put you in touch with the right people if you need some guidance on that. Yeah. So I'll turn it back over here.
I'm gonna jump on that really quickly. I think that for those folks who don't want to pay taxes in certain states, I think that's an example of a legitimate non-discriminatory reason to say we don't want to have a nexus in California, or we don't want to have a nexus in Minnesota.
Mm-hmm. Mm-hmm.
All right. Thank you both. And so next slide, we'll go to you, Rebecca. What does this do to ADA reasonable accommodations? Working from home, even before COVID, this was one of the most common questions about accommodations I get. So I look forward to hearing your thoughts.
So, and again, I'm just piggybacking on so many of the other panelists that talked about it, although I know many were talking about how we come back to work. The problem here, the problem from an employer perspective, is that before we used to be able to say we don't have remote work, we don't do remote work, that's just not something that we do. And if we've successfully operated for the past year in a remote work environment, it's going to be very hard to maintain that kind of blanket, our jobs don't lend themselves. And call centers or as we used to say, like clerical support. Those are all things that we used to be able to say, oh yeah, you absolutely have to be in the office for that. Well, my assistant, who I love, and so shout out to Julie Treecarton, she's been working wonderfully for the past year, right? Like not skipped a beat. So how could I possibly tell her next week if we all want to return to work, nah, Julie, you actually can't do your job from home anymore? I think it would be a hard way to justify that it's an unreasonable accommodation or it's an undue burden. So I think it's just changed the factual landscape. Again, the ADA hasn't changed. The scheme is still the same. It's just that now we have different facts to tweak whether or not something is really going to be hard on the employer to allow it to happen.
Yeah, absolutely. And what about policy considerations when employers are drafting their disability accommodations or their work from home policies? What kinds of things can they do?
I think that actually is a really good way to manage the long-term remote from work practice, because you do always have the right to demand a certain level of a performance. And so if your assistant wasn't actually doing what he or she needed to do in a timely manner, wasn't actually capable of reading documents on the screen without printing them, or whatever the situation is, I think you've got some performance metrics that you can hold people accountable to, and you should hold people accountable to while they're working from home. So I think you have to think about, can you measure those? So you have these performance levels, but are they going to be measurable in a remote environment? And then you need to measure them and you need to stick to them if you want to be able to have them be a defense to any kind of performance management that you implement.
Yeah, those are great points. One thing I'll add too that might be a good idea is to look at the essential functions you have listed in your job descriptions. Are those essential functions still essential, or were some of them tied to things that just didn't happen for the last year and then could be considered non-essential at this point?
Yeah, excellent point.
Thanks. So Melinda, back to disability benefits. So somebody's got an accommodation, this often goes hand in hand.
Yeah, no, that's a good point. I think this is kind of a push-pull of the pandemic. I think what we're finding is, so there's more remote work and it is possible. So does that perhaps decrease the likelihood that someone would be considered disabled because they can actually work from home? And contrast that with the potential for more claims for disability because of COVID itself. So I think that's to be determined, but those are some of the trends that we're looking at and keeping an eye on. Also, because of the pandemic, we're perhaps seeing less accidents, less travel, so less short-term and perhaps long-term disability claims. But what ultimately will the pandemic mean with respect to disability claims? Perhaps there will be more because of it. So those are kind of what we're looking at. We don't know, but those are the trends we are keeping an eye on.
Thanks, Melinda. So our next slide is, we're just going to gloss through. You can take a look at those questions because I want to make sure we fit in our last slide. Because there was at least one question in the chat box. So we can go to the next slide. There was at least one question about, oops, sorry, one back, Sean. Sorry about that, thank you. About whether employees, what about working in other countries? Rebecca, what are your thoughts on that?
Yeah, I mean, you absolutely have to comply with that country's laws if an employee is performing services in that country, which suddenly makes you an international employer if you weren't before. You have a presence. We cannot assume that other international jurisdictions are going to have comparable Nexus rules, or even how you characterize somebody as an independent contractor versus an employee. I know Ryan talked about that earlier in some of his remarks, but just because we might feel comfortable that someone's properly classified as an independent contractor in Minnesota, if they move to Canada, they might actually not meet an independent contractor test there. So now you have an employee in Canada. And so I think it really complicates the situation. And I don't think you have to let somebody keep their job if they want to go abroad. I don't think you're required to do that. You're not required to suddenly become an international employer because of that. But as Jillian said, the hard part of this is you don't do it with Susie Q, but that when Carol wants to move, you're like, oh, I love Carol. She can move to anywhere in the world and we're going to keep employing her. Right. Okay. So now what's the difference between Susie Q and Carol? And what have you stepped into that Melissa and Trevor have to get you out of?
That is a wonderful note to end things on. All-purpose advice here. So with that, I'll turn it back to Ryan to close us out.
Jillian, Tim, Melinda, and Rebecca, thank you. Very interesting, very timely, and very dynamic. So all of you out there, keep their names in mind, because this is not something that is done with what you heard today, I'm sure. More to come on that over the next year or more. So that wraps up our 2021 symposium. Thank you to all of you who stuck through it with us. If you do need credit, as you see on the screen, please return your completed sign-in to attendance@dorsey.com, and we will get certificates out to those who return that form. We've seen lots of great questions, and again, we miss out on the environment where we can interact more directly. But if you have questions that we weren't able to answer today, please don't assume that we're going to get back to you just because you entered something in chat. We will not. But if you have questions that you'd like to reach out to somebody, either a presenter or your Dorsey contact, please feel free to do so. We'd love to hear from you. That's all of our time. Again, we appreciate your attendance. We value your feedback. So when you return those attendance forms, please take an opportunity to tell us how we did, what we could do better, what would be valuable. We saw a couple of chats recommending follow-up seminars that we will certainly keep in mind. So once again, on behalf of everyone in the employment and other groups here at Dorsey, thank you and have a good afternoon.